Lunchtime Live. I am Jackie Tate-Naghi. I'm an associate at Aharoni Business Law. We are a firm that focuses on providing legal services for small businesses in the Bay Area. Today's Lunchtime Live presentation is entitled How to Achieve Tax Exempt Status. This is actually a smaller snippet of a larger program we presented last month at our Startup Series, which we present every month at the Port Co-working Spaces in downtown Oakland. So let's get to it. Before actually diving into the tax exempt status part, let's just go over the steps that you'll need in order to complete your nonprofit fully. So the first thing to do is to form the corporation. That's step one, and that needs to be completed prior to step two, which is applying for the federal tax exemption. After you apply and achieve your federal tax exemption, you're then going to want to apply for your state tax exemption. After that, you'll also need to register your charity with the Attorney General's office, and you'll also want to make sure that you have all the other licenses you need in order to do business in the state. So let's move on now to filing with the IRS. There's a form that you fill out, and this is the form. It's called a 1023, and it's for recognition of exemption from federal income tax under Section 501c3. There's actually two types of forms that you could fill out. You could, if you qualify, fill out a 1023-EZ. Now, this form is a lot more streamlined. And there is actually a worksheet on the IRS website to determine your eligibility for being allowed to fill out this more concise application. Basically, you'll be ineligible if your company is going to be making $50,000 a year in gross proceeds in the next 3 years, if your total assets exceed $250,000, if you were formed as a for-profit originally. And this actually happens a lot, that a for-profit entity may at some point decide to become a nonprofit. And also you will be ineligible to fill out the 1023-EZ form if you were formed in a foreign country. The long form, which is what most corporations will have to fill out, and which is what we're going to be focusing on here right now, is it's a 33-page form. And it's a long and arduous process to get through, from getting the form to getting all the information you need to fill it out, to actually having the IRS process the form, and to then actually achieve your letter that you have your tax exempt status. The different categories that the form goes through and the information that you'll need to provide is information about just identification, everyone who's involved with the organization itself. Board of directors will need to be named, addresses, etc. You'll also need to provide your organizational structure. You will be asked if you have certain required provisions in your organizing documents. So this is, including stating your tax exempt status in your organizing documents. You're going to need a narrative description of your activities. You're going to need to supply compensation for all employees, officers, directors, contractors, etc., and just any other financial information. You'll also have to divulge all of your fundraising activities. You'll need to provide a statement of revenue and expenses, and for this form you may actually want a CPA to help you out. You'll need to determine your classification as a public charity or private foundation, and you'll need to also fill out lots of other schedules depending on what type of an organization you are. So the IRS, they typically take about 3 to 4 months or longer to process the Form 1023 application. However, this waiting period could be a lot longer if your application has any errors or omissions, or if other information that requires a special IRS employee to process. So it's easy to make mistakes that can become costly later to correct. because it'll delay this process for, 4 5 months even. Different mistakes that you might make would be unwisely creating voting membership structures, adding unlawful provisions to template bylaws, or violating the commerciality doctrine. We do recommend having experienced professionals involved, such as attorneys, but you could also have, if you have a board member that has experience with nonprofit incorporation, that would be really helpful to get you through this process. If you also just bring in experienced consultants at any point, like for instance, having a CPA help you fill out your financial disclosures, that's something can really help you sort of get to the next step without making any mistakes and causing any unwanted delays. I'm going to focus actually now on 2 of these sections that the application goes through, which are really the most important. The first of those being your narrative description of activities. This section is actually the most critical, and it asks for all of your past, present, and planned activities. What constitutes an activity is basically just anything, really. Any sort of event that you put on, anytime you are, fundraising, those are going to be events that you're going to need to disclose information about. So the IRS is also going to be asking you, who conducts the activity, when is the activity conducted, where is the activity conducted, how does the activity further your exempt purpose? That's really an important one. What percentage of your total time is allocated to the activity, and how is the activity funded? And then they're also going to just want to know if you are conducting any activities using any alternate names. So if you're operating under like an alias, an AKA, or a DBA, doing business as, you're going to need to disclose that information and any activities under those names as well. The second most important aspect of this application, and really for your own knowledge as well, something you're going to want to determine for yourself prior to applying, is whether you are a public charity or a private foundation. So public charities are considered 509A1, and they, under this, receive substantial fundraising advantages. So donors and donations receive more favorable deductibility. You'll fall into the public charity wing if you receive substantial amount of income as grants and donations from the government and general public. You'll be considered a private foundation and fall into 509A2 if you receive a substantial amount of your income from membership dues or activities related to your tax-exempt purpose. Under private foundations, they usually make grants, or they can only make grants to public charities because they're taxed at a higher rate if they grant to non-charities. Public charity status is generally the more favorable tax status, but it does require an organization to meet those certain requirements. And for most organizations, this means passing a public support test over a 5-year measuring period. The public support test states that an organization must receive at least 1/3 of its total support from government agencies, contributions from the general public, and contributions or grants from other public charities, or at least 10% of its total support from those previously mentioned, and also satisfy a facts and circumstances test, which is a little bit vague, but that's why your narrative will be really important as well if you are, between 10 and 30%. For organizations that receive a large bulk of their support from only a few sources over their first 5 years, it's going to be really important to monitor and manage the public support ratio, because you could at any point in time lose that tax exempt status, and then the donations that you receive will be less incentivized because individuals contributing or organizations contributing will not have that tax benefit. It's important to remember that the process it takes time. So you have to be patient. It can take sometimes, months for you to even gather this information that you need to fill out the application if you're working full-time while you are, trying to apply for the status. However, you should be careful and considerate at every step to ensure that you are complying with IRS regulations, because if you at any point run awry, you're going to run into problems. After you do receive your exempt status from the IRS, the next step is, as I said, to apply for your state tax exemption. There's good news here because it's much easier to receive your state tax exemption. At least here in California, organizations with a 501c3 federal determination letter, which is something you'll receive from the IRS after you have, gone through the entire application process and been approved, you can request that California simply affirm your tax exemption by filing a Form 3500A. So the FTB will recognize your organization's exemption from state income taxes as of the federal effective date. So all you'll need to do is provide a copy of that IRS determination letter, fill out that application, which is nothing near as complicated as the 1023 form, and there isn't even a fee. Very surprising for any form that you have to file with government. Now, we know here that you wouldn't be an entrepreneur if you weren't self-starting, so you're probably very, very resourceful. But keep in mind, experts do know more than you, and sometimes it's hard to do everything by yourself. So it is possible to fill out this 1023 form. Just understand that there are certain risks, and at any point in time, it can be useful to bring in a business lawyer with nonprofit experience, such as Aharoni Business Law, or consult with your CPA who has nonprofit experience. Sometimes even a bookkeeper or, again, a board member can be really useful in these circumstances. Thank you for joining me today for our Lunchtime Live program. If you like, you can join me again in person on March 24th at our startup series on copyrights, or you can wait for a little snippet of that program for our next Lunchtime Live series, which will be sometime in April. I'll see you then. Have a good day.